Folks, welcome. Welcome, one and all. It is Friday, May 9th. We're back doing technically not a webinar. It is a Zoom meeting, which, yes, to get it out of the way, we are recording this. I did remember hit the record button, and this is going on YouTube. If you're watching on YouTube, hey, good to see you. Hope you enjoy what you're watching. Before you go any further, hit the like button. I've got some chapter markers so you can move around to see the parts that you like and leave a comment for us. Hopefully, well, maybe we'll get back to you. Maybe not. We'll see. But again, thanks for being here and thanks for joining us. We appreciate you being here. A couple of other housekeeping measures before I introduce my special guest. We've got closed captioning available. If you go down to the bottom of your Zoom screen, and it should be somewhere down there, maybe my screen's a little bit different than yours because of the way I have it configured, but somewhere down towards the bottom right, you should be able to turn on closed captioning. Let me know if anyone has an issue. I'll try and fix it for you on the fly. I did say that this is being recorded. Please like, subscribe, all that kind of stuff. And one more time before I introduce my wonderful guest, let's give you a disclaimer. Merlyne Jean-Louis and I, Eric Meyer. Oh, I should introduce myself to those of you who don't know me. That would have been nice. I'm Eric Meyer.
That's
I'm
hilarious.
Eric Meyer. I shouldn't have assumed that everyone knows who I am. I'm Eric Meyer. I am an employment lawyer at Pearson Ferdinand, and I am also the publisher of the Employer Handbook blog, which you can visit at theemployerhandbook.com. You can also connect with me on LinkedIn. Just look me up, Eric Meyer. That's who I am. I'm going to give the disclaimer and then I'm going to introduce Merlyne. I should have prepped this even better than it couldn't have prepped it much worse. Disclaimer, Merlyne and I are lawyers, but we're not your lawyers. Maybe we're your lawyers, but for the next hour, even if we are your lawyers, we're not your lawyers. Okay? This is a free Zoom meeting. Don't take legal advice from anyone, especially a lawyer, on a free Zoom meeting. So, any questions, and you can feel free to ask them in the chat. Any questions you ask, we assume you are hypothetical and you're asking them for a friend. If they're a little bit too specific and particular, we may just kind of duck them because then we might feel like we're infringing or encroaching upon giving legal advice. So there's that. Anyway, enough of me blabbering on. I have the official introduction. Merlyne Jean-Louis, it's great to see you. Thanks for being here today. Tell everyone a little bit
Thanks.
about yourself and what's going on.
Thanks, Eric. Thanks for having me. I am a business and entertainment lawyer. I'm based out in New York, licensed in New York and California. I like to say that I help businesses and creatives protect their ABCs, their assets, brand, and content via contracts, intellectual property, and business structure. I went to Duke for law school, NYU for undergrad. I'm also a legal commentator. I've been featured in Bloomberg, CBS, The Verge, The Hollywood Reporter. And yeah, go Knicks.
For this round, go Knicks.
Native New Yorker. So I'm very happy right now.
For
Very
this
happy.
round, sorry to all my Bostonian friends who may be attending or New England friends who may be attending, but for this round, yes, go Knicks. All right. We've got a lot to cover, and I think the first thing we should do is talk a little bit about we're going to talk about employees, we're going to talk about contractors, we're going to talk about all sorts of VIPs and where they fall. So why don't I start us off with a little bit of employee versus contractor, how the law looks at it, at least from an employment law standpoint, and then perhaps I'll turn it over to you, and I have a list of questions I'm going to ask you,
Oh,
Merlin, because
I'm ready.
uh, I do a lot of executive work, but I don't do a lot of VIP work, and I think I'm going to learn a lot today from you. But let's talk a little bit about how the Department of Labor and the courts generally view independent contractors versus employees, because that's important for our discussion today. So, up until a week or so ago, I would have said something different.
What happened? I'm curious.
What happened? What happened is the Department of Labor announced on May 1st that it is no longer going to follow the Biden administration Department of Labor's uh, independent contractor test. So
Huh.
the courts can do what they want, but for enforcement purposes, we're not going to follow it. Here's what we're going to do. We're going to take it back to 2008. when we used to use 7 economic realities factors in order to determine whether someone is an independent contractor or an employee. And in brief, those factors include control, so how much control the business asserts over the individual, the permanence of the relationship, the level of investment into the relationship, the skill that the individual who is engaged utilizes, that person's opportunity for profit or loss, the integration of that person into the overall business of the company that is engaging that person, and then the degree of independence that the individual has. If this sounds a lot like the 2024 independent contractor test, it's because it does. It's not the same, but if you were to draw a Venn diagram, there's a lot of overlap. Here's the takeaway. Your mileage may vary. Your
So,
mileage may vary, and there's no one there. Every situation is a bit different, but you have 7 factors, according to the DOL, that get thrown into a pot, stirred around. You take a whiff. If it smells like independent contractor, it's independent contractor. If it smells like employee, it's employee.
so quick
Go
question for
ahead.
me. Must all these factors be met in order to be someone to be classified as employee, or is it just it depends?
Great question. It is, and I'm going to turn it over to you for an ABC test if you don't,
Okay.
if you
Yeah,
will in a
sure.
second. But this is not like the ABC test. This is a totality of the circumstances approach.
Okay.
So
And this
a
is for
couple
federal purposes, federal purposes.
federal purposes, right?
Okay.
And this is strictly for Department of Labor purposes as of now. I think what you'll see going forward is that Department of Labor, this administration will rescind. I'm predicting. I'm putting on my, I'm looking at my crystal ball. Will rescind the existing independent contractor rule and make the 2008 test the new rule. How that moves the needle all that much in determining whether someone is an independent contractor or employee, anyone's guess. But at least at the federal level, it's going to be a totality of the circumstances test. But Merlin, at the
Yeah.
state level, it's a lot different, isn't it?
Yeah, it can be. So certain states like California and New York, and I'm not an employment lawyer. I just know what I know for the states I'm in, just on a surface level basis. California has one of them interesting tests, an interesting test. They 2020 they released the AB5 law, which says you have to satisfy the ABC test to be classified as an employee. The ABC A is the worker is free from control and the direction of the hiring entity. Uh, B, the worker performs work that is outside the usual course of the business that hired them, their business. And C, the worker is customarily engaged in an independently established trade, etc. So, like for example, prime example is this for me. I think about someone hiring a graphic designer for if they're like a landscape company and they're hiring a graphic designer to redo their website, right? You look at this test, the designer is people control, their work is not related to landscaping, and they probably have their own business where they're also probably engaged by other companies as well. So that sort of person is clearly a contractor. Um, why is this important? I can talk about, a situation later on for what I think of, what I had a California client. Well, I had a client of mine had a California contract and we sort of like mixed the two. They were influencers. So my VIPs that I work with are influencers, content creators. Those are my VIPs. They had them do something. There was a physics company that had them do something, and they wanted them to classify them as an employee for this particular thing. But I believe what happens with employees, if you are an employee, you have to pay taxes for that particular income that is made as an employee. It was a lot of money. We didn't want the entire thing to be done under that. So we were able to parse up different parts of the contract where we're saying, hey, you're paying this person, you're paying my client this amount of money for these services, but this other part, this other obligation, we're going to have it as an independent contractor because technically it was.
And for me, for my audience, HR professionals, in-house counsel, we're usually focused on wage and hour. We don't, I mean, tax is an implication, but we're usually looking through it through the lens of whether someone needs to be paid minimum wage and overtime or whether they're exempt from that. So when we're talking about people in the C-suite, these are folks who are almost always employees rather than independent contractors. Now, you could have a situation where someone's a fractional or interim executive. So, how would classification work there? I mean, you might want to label someone an independent contractor, but even taking the totality of the circumstances test, you're probably looking at an employment relationship. But for wage and hour purposes, unless you're paying that person something other than a salary or a fixed fee for like a month or a few weeks, something that is essentially a kissing cousin of a salary, it's not really going to matter because that person will be exempt under the Fair Labor Standards Act exemption test, probably an executive level exemption, probably, or maybe administrative, for example. So it almost, I don't want to say it never matters, but the
Mhm.
odds that it turns someone from an otherwise exempt, you don't have to pay them overtime individual into someone who is entitled to overtime, the odds are, I don't want to say slim and none,
Mhm.
but they're low. They're low. Uh, One other thing we should touch upon here, and then I want to ask you some questions about all this, 'cause I think the audience would be really interested in it, is whether forming an LLC or an S corp somehow changes the legal analysis for someone in the C-suite. So let's say I engage a fractional a fractional leader in the C-suite, and I engage them as an LLC. Does
Mhm.
that make much of a difference? Probably not. And actually, if you look at it more on the state level, the Department of Labor in New Jersey, so another state that has an ABC test, just came out with proposed regulations about how it's going to enforce the ABC test. And in doing so, it said that forming an LLC means nothing.
Right.
Means nothing. You look at the reality, like what is the relationship between the individual who's performing the work and the entity that is engaging that individual, and do you satisfy the ABC test without consideration of whether they're an LLC or an S corp? So let me ask you. I again, my sphere is generally the C-suite, unless VIPs,
Mhm.
uh, content creators, influencers. How is classification typically handled in the entertainment industry? And are there practices or norms, Merlin, that differ from other industries?
Mhm. Well, I think every agreement that I've seen with my clients has had a clause that says independent contractor, where you're very saying clearly that you're not an employee, that you're a contractor. But as you just said, it doesn't really matter. You have to look at the nature of the relationship to determine whether that classification is accurate. I see a lot of what's happening. This happens a lot in film and TV as well, is that these content creators, influencers, these VIPs, they have a one-up company. And it's similar to what you just said, right? Someone from your LLC or corporation, and basically having that corporation or that entity loan out their services, their creative services to whoever, a brand or, a production company, etc. And you can sort of think of it as the loan out being a middleman for the transaction. So sometimes what I see in agreements are that the party is listed as the entity is listed as a lender, but then also the individual who owns the entity, the loan company, is listed as talent, and then you're referred to them throughout the entire contract. You're saying lender is going to force talent to, or going to make sure that talent does X, Y, Z, even though it's the same person, the same thing essentially. And sometimes I see where you have company entity FSO for services of the person's name, and that's it. And there's just one that says, talent essentially. So essentially, it's the same concept, like in terms of how they're classified in agreements, but you just want to make sure that the entity is a party in that contract. And for liability purposes, it makes sense that a VIP doesn't want a company to go after them personally. And so there's sort of separation. Also, if there is that lender language throughout mostly the agreement, the lender and talent agreement, what you're going to see is another section called inducement, like a small section that says, hey, lender, you're going to induce the the talent to do XYZ. Is a little letter page that's sort of standard in this area.
Fascinating.
Yeah. And I feel this world that I'm in, VIP, is like it's an influencer world is taking from the the areas of entertainment that have been existed for so long, where we have TV, we have film, we have music, and so a lot of the contracts are trying to like figure out, okay, like we're trying to create a hodgepodge of language to figure out what applies here. So that's something I think. Because loan out companies also can apply to music as well. Like you have a producer, they have a loan out company for their production services.
So let's say you have this hotshot influencer,
Hmm
right? 3 million followers, wants a private, I don't know if 3 million followers is enough to trigger wanting a private jet perk, but whatever, and doesn't want to be called an employee, right? How do you pull that off without triggering a misclassification claim
So
from?
this is outside the realm of my area of expertise. So I would say if this is a situation that, the company that's hiring the influencer, I would definitely say talk to an employment lawyer like yourself to ask that question. Um, I just wouldn't know how to
Is
respond
it
to that.
is it fair to say, and this is more like kind of a practical view of the
Uh-huh.
situation, right? We have an engagement between an individual and an entity, right? An influencer and an entity. The influencer probably wants to be paid, I'm making this up, like with as little withholdings as possible, wants to,
hmm
probably might be to their benefit financially, at least in the short term, to be an independent contractor.
hmm
Maybe the company doesn't care. I mean,
hmm
I guess unless the IRS is going to come in and do an audit. I
Yeah.
mean, what are the odds that the relationship sours to the point where the influencer turns around and says, "You've misclassified me. I want my overtime,"
So
right?
honestly, being honest, for most of the agreements that I've seen, I can legitimately say that I think that the influencer should have been classified as a contractor. There's no issue. I think the instance that I'm talking about that happened was that there was services rendered over a period of time, and the influencer was there for a period of time. So I can see why they would probably be classified as short-term employee. But for the most part, I get agreements where someone is creating content and they're using their own film and they're using their own like plays to do that. So I think in actuality, they're classified correctly. But I got that one instance where I'm like, and that was just that one time. I guess, and the onus is on not them, right? It's probably be on the person that hires them to make sure they classify correctly,
Correct.
you
Correct.
know?
The onus, yeah, that's a great point, Merlin. The onus is always on the employer
hmm
to establish that it's a contractor, that the individual is a contractor. And then if the person's considered an employee, the onus is on the employer again. Now, technically the employer, no longer the business, the
hmm
employer, to establish that an exemption applies. The onus is never on the individual to say that to prove or that they are not exempt, right? That's the default assumption. And then it's up to the employer to show that no, there's an exemption that applies here. All right. Let's pivot a little bit.
Let's
Let's
do it.
talk about the agreement itself, right?
Uh-huh. That's my bread
So,
and butter. My bread and butter.
oh, then I'm gonna speak very little and then pass it off to
And
you.
I
I
talk
just
really
want
fast, y'all. I apologize. I talk really fast. And so you can, if you're on YouTube, you can slow this down by zero point 0.5 or 0.35. There we
don't
go.
go to 2.0.
No, do not.
Right. Okay. So I'm looking at it again through the lens of I'm hiring someone for the C-suite.
hmm
First off, I probably more likely than not want an employment agreement rather than an offer letter. Why? Because I may have provisions like I can only terminate the person for cause, or if I do it without cause, there is some sort of severance that gets triggered. I want a more robust set of restrictive covenants that, while I could put it in a side agreement to go with an offer letter, having it all in one document, one governing document, makes a lot of sense. So if I want to, and we'll talk more in detail about restrictive covenants later, but if I want restrictive covenants, I can put them there. Maybe a non-disparagement provision. Generally not something suitable for an offer letter. I put that in a contract.
hmm
There may be provisions that we'll talk about this more in a bit. Forum, venue, governing law, stuff that's not generally seen in a standard offer letter. I'd want that in an employment agreement. And then confidential information, intellectual property, and Merlin's going to talk way more about this than I am, but making sure that you've got those clauses and then structuring them to account for inventions, if that's something that someone in the C-suite may be doing. Perhaps not. Maybe that's more of your creators or people outside of the C-suite. But if there are systems and proprietary methods that those folks are involved in, or they at least have their fingerprints on, you want to make sure that that intellectual property remains with the company. And then kind of on a tangentially, if you want to make sure that they have a duty of loyalty to the company. If someone's going to moonlight and be in your C-suite, like that could be okay if it's for a completely different business where you're not at risk of having them share confidential information or use your intellectual property. But these are some of the terms and conditions that you would typically find along with salary and bonus and things like that. I mean, that's obvious. But we're talking about some of the protections that you would typically find in those types of agreements from the C-suite. But the folks here, they're probably interested in that, but I'm way more interested in what goes into a VIP agreement because that's your sphere, Merlin. So when you're working with
Yes.
VIPs,
Hmm.
how do you typically define the scope of services and structure their compensation? Do you see more like flat fees and revenue
Hmm.
sharing, or is it performance-based bonuses? What's going on?
I see a lot of detail. The services, scope of services is quite detailed. Usually I'm working with brands who are hiring these influencers for a campaign. And so it makes sense for them that they would be as specific as possible as to what the influencer is going to be doing and provided, the services they're going to be providing, because we don't want something called scope creep, right? We don't want them to describe the services broadly and then um, the influencer is open to interpretation as to what they're doing. That you never want that in agreement. Ambiguity is the enemy when it comes to contracts. We learned this in law school. Like you have to be very, very clear, right? Because lots of things can happen when terms of a contract are ambiguous. Not good.
Especially
Um,
when you're the one drafting the agreement and writing the check.
correct,
Yes.
correct. In terms of fees, what I normally see is a flat fee. However, this is sometimes it's sort of given in stages. Like we're going to give you this amount when the contract within 5 days of the execution. And then after the work is actually performed, we're going to give you within 45 days of the post being put up on social media. That's what I've seen a lot. It can depend also whether you're, if you're in music. I don't really know music, but I'm pretty sure their particular payment system is a little bit different. Um, in terms of, I think another provision I want to talk about is IP, right? Intellectual property. That is very important if you're working in creative space, right? Content is king queen in this industry. And so you want to think about, is the company that's hiring the VIP, are they gonna own it? Or are they going to have have the creator own it and then sort of have them license it back? So here's what it makes sense. Sometimes it makes sense for the company to own it. If you're working in film, right? If you're working in film, you're hiring actors, you're hiring all these people, it makes sense that the production company is going to own the rights to whatever content is created by the actor. Or let's say there's a script, but then this actor does something that's really off script, and that's their particular, that's their IP that they created off the cuff. You want to make sure that the production company owns it, right? Because if they're going to be distributing it, all these things, you want to make sure that it owns it. And so what happens then? The price goes up depending on the bargaining power of the talent that is actually included in the film. Think about one thing that comes to mind for me. Oh my gosh, Ryan Coogler in Sinners. I don't know if you heard about this. Sinners is a phenomenal movie. He's the director, writer, producer of this. He was able to negotiate with Warner Brothers, the entertainment studio, that in his contract he's going to have a reversion right. That basically means in 25 years he's going to get the rights, all the rights, IP rights back to the content that he created, right? So he created all the things, right? But he for some time gave it to Warner Brothers to do whatever they wanted for 25 years, and then it's going to go back to him. That's unique in this space, in the movie space, in the film space, but it is very, very good because this movie is doing great. So that's good for him. When it comes to content for brand campaigns, I've seen both. I've seen reputable companies want all the rights to the content that's created by the creator, which is fine, right? If you're creating content for a car company, like, sure, why not? Like, whatever. Like, it's this choice of the brand itself. But sometimes I've also seen reputable companies have the content creator own the content and then have a very broad license. License. So I need to sort of break this down. IP rights are created when it comes to content. If something's copyrightable, we have three things. A work has to be a work of authorship. It has to be a work that's listed in the Copyright Act. So it could be a video, it could be music, etc. It could be lyrics to a song, it could be novels, etc. It has to be original. The author has to have used their own creator's uses to create the work. And number three, it has to have the ability to be fixed in a tangible medium of expression. What does that mean? So if I say the lyrics to Thriller, I say them verbally. As soon as I say them, they're gone. They're gone with the wind. However, if I write it down on paper, right? The paper is tactile, can you touch? Back in the days when the 80s, they had cassette tapes, you put it on cassette tape, press play, the tape could be touched around that using the little fingers, whatnot. But a tangible meaning expression means it's fixed in something that can be touched. So again, so long as something is a work of authorship that's original and has the ability to be fixed in a tangible medium of expression, you have copyright. In the United States, that means that the owner of that work has the exclusive right to do whatever they want with it. In law school, they taught us to think of the rights as a bundle of sticks. The right to perform the work, the right to transmit the work, the right to copy the work, the right to, a very important right, the right to create derivative works that are derived from the original work. Think about Harry Potter, right? Or Jurassic Park. They originally were books, but became movies. Harry Potter also is actually a Broadway play. So that derivative right is what made J.K. Rowling a billionaire. It's what made Michael Crichton, very well off. And so it's a very valuable right. Is that person the owner's exclusive right? If someone else wants to engage in those rights, they have to ask for permission. So if they don't, that's copyright infringement. If someone engages in those rights without the permission, it's called copyright infringement. And so you can either get those rights by having the owner assign them to you, which is selling them like a house. Like, hey, I'm the owner. I have the deed to the IP. I'm selling it to you outright, or I'm going to give you a license. I'm renting it to you under these circumstances. And so again, sometimes the brands have that the content is going to be owned by the content creator, and then it's going to be licensed, so rented out on a broad scope for the brand.
Have you ever dealt with a celebrity who thought they owned everything, including things they didn't actually create?
No, I haven't had that situation happen. I think a lot of creators are savvy, or a lot of them are savvy, but I haven't had that happen. I can't say never. Have you? I'm just kidding.
I have not. I have not.
Okay.
What about some common misconceptions VIPs or their reps may have when it comes to IP ownership and
Yeah.
licensing?
I think one that I've seen a lot is related to another part of IP, not copyright, but trademarks. I think people sometimes have it happens a lot. They don't understand how a trademark works. They think that they can create a word, or they just create a word and it becomes theirs. For trademark rights to actually be exploited, you have to use something. It could be words, it could be logo, etc., in association with the sale of something. It has to be the association with the sale of goods and services. And so you can own that word so long as you're using it in commerce, across state lines in association with the sale of something. And so I think that is something that, regardless of whether they're VIP or not, I've seen that a lot in terms of trademark, what it actually means.
Well, folks, we are about halfway through.
Are we?
I'm Eric. That's Merlin.
Okay, yes, we
Thanks
are.
for joining us. We appreciate having you here. We've been talking about VIPs and executives and the types of provisions that you'd want to see in that agreement. Also, we did a
Yeah.
little discussion on employee versus contractor, and now we're going to move on
Wait,
to
before we go,
managing.
can I just
Yeah,
quickly list off some other provisions that are very important in agreements?
please.
We have reps and warranties. So if someone enters into an agreement, you're saying that I am attesting that what these facts are important, right? Because that's important, because a brand is going to depend upon these reps and warranties to enter into agreement. Some common ones, like I attest that I own all the rights to the IP that I'm creating. I have the authority to enter into this agreement, etc. We have indemnification. Indemnification is basically, you can think of it as reimbursement if something goes awry between party A is brand, party B is VIP. Because of the agreement between party A and B, party C gets injured, either goes ahead and sues party A or B, and then if party C wins against either or, the party that lost can go against the A or B to go ahead and get reimbursement. Think about that. Limitation liability, something that if you're a brand or you're hiring VIP is something you want to think about because you want to limit the amount of money, the maximum amount of money that one can get outside identification. And termination. You always want to have the ability to get out of a contract. I've seen some agreements that don't have that. I don't think it's a good idea. I think you want to have provisions that let everyone have an out. On top of that, if an agreement is terminated, there are going to be some clauses that survive, right? IP, just because the agreement ends, you don't want the rights that were established regarding to IP to end. So IP usually is in there, identification, what's of warranties usually survive. Governing law, depending on what type of content or type of content is being created, you can choose a state which governs the contract, right? If you're entertainment, maybe in film, maybe New York or California, because they have really strong laws related to those, So those are just some other clauses I'm thinking about. Another important one, if you're engaging a VIP and they're creating content or something for you, you want to have language that says that they're going to have the ability to, if they're using someone else to help them with their work, that they're going to ensure that those third parties, there's agreements with those third parties that are signing rights back to them. That's basically a rep and warranty you want as well. That was really fast. I thought I talked fast, so slow this down if you're on YouTube.
That's okay. For reps and warranties, I'm glad you mentioned that. I mean, I'm going to talk a little bit now about restrictive covenants. I foreshadowed it earlier, and one
Mhm.
of the reps and warranties I'd want to have in my employment agreements that I draft for someone in the C-suite, or frankly anyone uh, in or out of the C-suite, where they sign an employment agreement, even in an offer letter,
Mhm.
is you don't have a current or otherwise existing agreement that prevents you from working for us. So, for example, a non-compete or a non-solicitation provision. If you're a salesperson, yeah, technically you could work for us and not solicit your old customers, but what are the odds that that is what's going to happen in reality, right? We want to know about that. We want you to represent and warranty that you're not going to bring anyone's confidential information into our house. We don't want it because once it hits our servers, that's bad. That's bad. Then we have a problem. So those are some of the reps and warranties I'd want to see there in from an employment C-suite standpoint at the very least. You mentioned Merlin. You mentioned forum selection and what law is going to govern. I mean, geez, if I can help it, I'm not licensed to practice in California, but I'm not having California law be the governing law, especially if I'm going to put a restrictive covenant in, right? Because under California, you can't have a non-compete, you can't have a non-solicit, but in other jurisdictions, you certainly can. Uh, so that's something that is a pretty important consideration as well. But let me pause there for a second and pull it back, focusing less on which state law is going to apply and can close the loop on restrictive covenants. So for folks in the C-suite, you're probably going to want the full array of restrictive covenants. And what I mean by that is a confidentiality provision to prevent the use or misuse of confidential and proprietary information, a non-solicitation provision, which would prevent that individual from soliciting not just business from if they leave their former employer, me, uh, but also employees or contractors or vendors or interfering with any of our business relationships. And then ultimately, if the person is important enough and there is a legitimate business interest to do so, I would want to have a carefully tailored, reasonable non-compete to prevent that person for a reasonable period of time in a reasonable geography from competing with my business.
And ask a
Though
question.
Those are generally available to employers in not all states, certainly not California, certainly not what other states? Minnesota, Oklahoma, North Dakota. I'm forgetting one. Some states have limitations. One state like Florida right now is looking to push non-competes out to 4 years. I saw legislation for that
Wait,
to make
I'm
it.
sorry again, say that again. They are trying to.
Florida is bucking the trend. So where you see a lot of states that are trying to restrict the use
Mm-hmm.
of non-competition agreements,
Oh,
Florida's going the other way.
got it. Okay.
And I read today on LinkedIn pushing legislation to allow for non-competes of up to 4 years, which, unless it's in connection with the sale or acquisition of a business,
Mm-hmm.
like that seems like a lot
Yeah. I had
for,
a question about
yeah.
the FTC non-compete rule. What are your thoughts about it? Possibly almost.
It couldn't be more dead. I mean,
Yeah, oh, it's definitely dead. It's
let me put it
definitely
this way.
dead.
Let me put it this
But
way. I mean, I think technically kicking around in the Ryan case and
mhm,
in the Villages case in Florida, but it's just because the FTC hasn't completely pulled the plug on it yet.
mhm,
But it is like they're not enforcing it. Now, could something pop up in its place, right? That's possible. I'm
mhm,
not saying that employers are in the clear from a federal standpoint on non-competes, but the FTC's proposed rule, which would have essentially done away with non-competes except in limited circumstances.
mhm.
Again, this is just federal. Your mileage will vary at the state level. From the federal level, it is pretty much dead. Can I ask you a question, Merlin?
Yes.
So we're talking a little bit about non-competes and somewhat related to that, I would think, are exclusivity clauses with
Hmm.
VIPs. How do you approach those and what's reasonable? What's
Right.
overreaching?
So prime example that I see that in contracts that I see is, let's say influencer is hired by a laundry brand, right? Let's say Tide. I'm hypothetical Tide, right? They do a post. What I've seen a lot is that there's a period of time after the term of the contract, whatever we determine that end of term of the contract to be, that the influencer is not going to create another post or um, endorse the brand of another competing laundry detergent company. I think that makes sense. I'm being honest. Like, I think it makes sense that, because number one, but that being said, I don't think influencers would do that too, because they would seem like they're selling out to their audience. And so it's there, the exclusivity. Sometimes I've seen a month, sometimes I've seen a couple of months. I haven't seen more than that in terms of exclusivity. But I think it makes sense too, because it's like you don't want the sort of attention that was garnered by that post to be sort of mixed in with someone else's brand. Makes a lot of sense to me. But again, I think that's the nature of the way the industry works. Influencers are not going to have the same types of brand campaigns back to back anyway.
What's your take on morals clauses?
I've seen them, and I'm like, I I think what I've seen a lot, especially younger generations, they value authenticity, someone being authentic, whether that be for, I wouldn't say good or bad. That's not the right term. Well, authenticity. Like no one wants someone who's evil, like who's going to commit violence. That makes a lot of sense, right? I have seen that sometimes, and I sometimes push back on some of the language that I've seen. Like they say that, um, what's something that I've seen that I had to argue against? Like engaging in behavior that is um offensive. I'm like, to who? Like, it has to be the reasonable person. We have to have some type of parameters on this, right?
Right.
So, like, I have to have like the reasonable person will find this offensive, reasonable third party, not you who works in the company. No, we're gonna have that type of language in there. So, I've seen them. I'm okay with them, but sometimes I've had to modify the language within them.
Gotcha. Yeah, there's a fight
Right.
often when we're dealing with what's going to constitute cause for termination, and we're getting into morals and
Hmm.
things like that, and
Some content creators are popular because they're abrasive, because they curse a lot. So why are you going to engage in a brand deal with a company and have rose clause with that person when you know who they are?
Right.
They've
Right.
shown you who they are. So
Right. That's precisely true. What are some of the more, and if this is an unfair question, I apologize for putting you on the spot, but do you deal with like surprising regulatory pitfalls, whether it's
Mhm,
from like the FTC enforcement guidelines or
mhm,
SEC rules for financial influencers? Is that
mhm.
something you deal with?
So fun fact, I worked at the FTC during one summer during law school. So
All
in
right.
the advertising and the profit. And so that is a big part of that is an agency that does govern a lot of the activity within the content creator influencer marketing space, which makes sense. Well, you don't want someone, it needs to be very clear that an influencer is endorsing a product, like hashtag ad, hashtag sponsored, even have like IG, Instagram has this paid partnership, so it's quite clear. I personally haven't seen, but in the news, I've seen this. I've seen recently there's a case, a class action against the company Revolt, which is a retail brand, where there were several influencers who did not make clear that the content they were producing regarding Revolt was paid for, was compensated. They did not use hashtag ad, did not use hashtag sponsored. There are about, I think, three or four influencers who are being named as defendants in this class action lawsuit because I read the case, and the plaintiff is saying, had I known that this influencer was actually paid to create this content, I probably would have bought it. And as one of the causes of actions, you have the FTC. One SEC that I remember, was it Kim Kardashian? Think Kim Kardashian had something where she was maybe someone else. I think it was Kim Kardashian where she was endorsing a cryptocurrency and she didn't make clear that this was an ad, and the SEC fined her I think $3 million. It was a hefty fine for the normal person. For her, I don't know, but it was just you want to make sure, depending on the type of content that you are creating, you want to make sure you're following the regulations of the agency that is in charge of promulgating the rules. Food, FDA. The Concentration General, FTC. Anything financial, SEC. So we want to keep that in mind and engage attorneys who can help you source that out.
What's the weirdest or most impractical clause
Uh-huh.
someone's tried to include in a VIP agreement that you've
Oh,
seen? Putting it to you here. Hopefully you got a good cocktail hour story.
I don't know. I'm trying to think. I've been doing this. I've been in space now for about 9 years in the influencer marketing space. There are early agreements. I don't know if I've seen impractical clause, but I just say that it was clear that the agreements that I saw were not sophisticated.
We're not sophisticated.
No, it was clear that the agency that sometimes you have in this world, you have intermediaries, you have agencies talk to the brand, and then the agency talks to my client. That's what I've seen a lot. There was one instance where I was like, this is so egregious, where it's clear that you are creating a contract based on three different contracts. Why? Because you have contracts, the terms that are capitalized are usually defined. It was clear to me that this agency did not create their own contract, and I was like, it is not fair to my client for me to spend my time fixing your mess. I said it nicely, more nicely, but I had them go back and give me a better agreement because that was egregious to me. Like, come on, you're making so much money. I know if my client's getting this, I know you're getting a lot more money. You can pay a lawyer to go ahead and create a template for you. It's okay. It is fine.
That's reasonable. That's reasonable. Have you ever had a situation where a company wanted to fire a VIP but couldn't because of how the contract was written?
I've had an instance
Or,
where a VIP, go ahead,
I
go
was
ahead.
going to say, or the converse, where a VIP wanted to get out of the
Yes.
contract.
Yes. That's what I've
Yeah,
had. I
yeah.
represented an influencer, very popular influencer who wanted to get out of the contract. And I'm like, I read the contract and I was like, you can't. You just have to wait a little bit. And I was trying to get them to understand that they ultimately we end up parting ways. But I think sometimes uh, some people who are influencers sometimes can think that just the fact that they are influencers means that they can sort of skirt whatever a contract says. I'm like, no, contract's a contract. If you had this thought at the beginning, you should have had different terms before you enter the contract because once the contract is signed, you must follow by the terms of the contract, abide by them. And so I think that this is something based on that. Like, it's a lesson. Like, hey, if you're not happy with the terms that you see, you can always negotiate them up front. You always, and that's the time you have the most power. Regardless whether you're the brand, whether you're the VIP, that's the time that you come to the meeting of the minds to come up with the best deal that works for everyone.
Yeah. All right, folks. I want to close out with a discussion on when the contractual arrangement ends. All right, so we've talked about the formation of a contract, the terms that we're looking to see in there. We've talked a little bit about forum selection and choice of law, but now the contract or the engagement is ending. So, what are some of the options that companies should consider in anticipation of ending the engagement and maybe a not so amicable break
Hmm.
of the engagement? So, for example, let me
Hmm.
stop talking in vague language and be more specific. So, let's assume I draft a contract for an employer that hires someone for the C-suite. In anticipation of that employment arrangement eventually ending, I've got to think about, well, if there's a lawsuit, do I want it to go forward in court or do I want to move that matter into arbitration? Arbitration agreements are very popular, but one of the big appeals of arbitration agreements is you include a class or collective action waiver with that arbitration agreement. So, in the wage and hour space, for example, you're not facing claims, you're not facing one lawsuit from 1,000 employees who claim that they were underpaid, but rather each of those 1,000 employees would have to go to arbitration on their own to bring that action. So, on the plus side, your overall damages probably go down because you're probably not going to face 1,000 arbitrations. The downside, if you do face any number of arbitrations, that can get pretty expensive to defend instead of having it consolidated into one lawsuit. The considerations really aren't that similar for someone in the C-suite because what are the odds that they are going to join a class, right, and bring that claim? So, really, it's more about the publicity of a lawsuit versus the privacy of arbitration. That is one consideration there. Another one is avoiding a potential jury trial. In some jurisdictions, you could push for a maybe a happy medium of a lawsuit but a jury trial waiver in the agreement. So go ahead and sue in court, but the case is getting tried before a judge instead of a potentially sympathetic jury. And then another thing that I like to put into my employment agreements is a, not always, but it's a consideration, is kind of a not kind of, a cooling off period. So if there's some sort of dispute that arises between the executive and the company, there might be a mediation provision in there where, first step, the parties try and work out the dispute amongst themselves. If they can't do that, rather than having either side rush right to court or to arbitration, you go to mediation, where both sides agree to split the cost of the mediator, and you have someone who, deals with these types of situations, someone that the two sides can agree on, and perhaps you can work the matter out uh, in mediation rather than spending all the money on arbitration or on litigation. So these are some of the things that I'm thinking about for executives. Merlin, for you, what's your go-to
Hmm.
recommendation on dispute resolution in VIP contracts? Are you thinking
Yeah.
about mediation, arbitration, litigation? What are you
So,
thinking?
yeah, so what I've done before that I said, hey, before we even get there, before we get to mediation, arbitration, I have that the parties first try to, in good faith, try to work out themselves. I don't want them to think that, oh, just because there's some type of conflict that they immediately have to go to this. I'm like, I would hope, and I make it clear in the agreement that they have that. I'm okay usually with provisions like that. I do explain to my clients though what it means. Like arbitration is not litigation, but still could be very costly. Keep that in mind. The venue of the arbitration. If my client is in, the Mid-Atlantic and the party they want to do arbitration, um, in California, like that's going to be costly to my client. So sometimes I try to add in I don't know if it still could be done by via video conference, like try to have ways to minimize the cost to my client. In terms of, here's something that I'm concerned about with regard to dispute resolution. There's usually a clause that says if there's a dispute and one side wins, the prevailing party is going to be entitled to attorney's cost and all those things. I usually, if I'm representing the VIP, I say no, because my VIP versus a brand that has all this money, like, yeah, they can afford that, but not my particular client. If it was the other way around, I would say I would probably add it in. So that's just something I thought about. But I'm okay with those clauses. I understand the rationale behind them. I understand what you said. Like, I don't want I could think about why a brand would want privacy with regards to that. So I'm usually okay with it. But again, I try to look at pieces of that clause and get my client the best situation possible. Basically what I could do.
You talked earlier about clauses that you want to survive
Mhm.
the termination, right? We talked, from my standpoint, it's
Mhm.
the restrictive covenants,
Mhm.
confidentiality, the
Mhm.
non-compete, the non-solicit, of course. You
Mhm.
mentioned the intellectual property rights.
Mhm.
Anything else?
Yeah. Payment. So right, just because
That's important.
just because these agreement ends, there's sometimes language that says that even if this agreement is terminated, then we're still going to get the pro rata rate of what was supposed to be given to my client. What else something that I have survived? We call it miscellaneous provisions, severability, governing law, assignability, like these, like there's a lot of provisions that are boilerplate within agreements that we want to have survive the agreement as well. I'm trying to think of else. Services, payment. That's what that comes to mind for me.
That integration provision, the boilerplate,
Yes.
it's usually like paragraph
13 or something like
19.
that. And then 13.1, then 13.2. Just
Okay.
say that's what I do. I was like, hey, this whole thing, miscellaneous provisions. This is what I
Yeah.
do.
I write some long ones. So maybe it's like
Ah!
19 or 20 for me, you know?
Ah!
But that integration
Uh,
provision is really important,
mhm,
especially if you're entering into some sort of a separation agreement that follows the termination of employment.
mm,
Because think about it. We have an employment contract that includes a confidentiality provision or non-disclosure provision, right? To be more precise,
mhm,
a non-compete, a non-solicit, okay?
mhm,
Perhaps some IP language. Now we write a separation agreement
mm,
that follows it, and we forget or intentionally do not include those restrictive covenants in the separation agreement because the separation
mm,
agreement's more about like you waive your claims and we're paying you some money and that and both sides go their separate ways. If you have an integration provision in your separation agreement, the integration provision basically says, I should have explained this at the top.
mhm.
This is what we're signing right here is the governing document between us, and anything else that we've entered into in the past means nothing. This is the governing document now. If you forget to reincorporate all your restrictive covenants, they're gone. They're gone based on the integration provision. So
Oh, interesting. Yeah.
that boilerplate can be pretty important. Like we overlook it. Like, are we going to sign wet signatures or DocuSign? All right, that much. Like,
Right.
who cares? But but the integration and the
Yeah.
severability and things like that, those are actually they can be important.
I would also add, I mean, I don't think companies are going to do this, but not disparagement. You want to make sure that both parties agree not to disparage each other after.
That's right, and that's
Mhm.
something that this audience. We have a number of employment lawyers I see in the audience, and I recognize some HR professionals in the audience. In this new administration, once we at some point have a quorum at the National Labor Relations Board, I would imagine that the rules are going to change on what is considered a lawful non-disparagement provision. The way it sits right now is employees, you can prevent someone from making statements that are like knowingly maliciously false. But anything short of that in the eyes of the National Labor Relations Board could chill their ability to discuss terms and conditions of employment. So the NLRB could overrule them. Also, on a related note, confidentiality of the agreement. So the financial terms can be kept confidential, but the other terms of an employment agreement, which relate to terms and conditions of employment, the Biden administration, that NLRB said, well, you can't stop someone from talking about their terms and conditions of employment. So if you have an overly broad confidentiality provision, we're going to strike it. And there may be other relief associated with that. So I think going forward, the pendulum is going to shift and that's going to change under this administration. But we don't have a Actually, I've lost track. I don't know if we have a quorum anymore at the National Labor Relations Board. I forget if Gwen Wilcox is back or not, quite candidly. But going forward, at some point, I think that's going to change.
Interesting.
Yeah. Yeah, I gotta say this, Merlin, we must have been really good today because I don't see, unless I missed it, I don't see any questions from the audience.
I don't
We have about
either.
4 minutes
I
left.
don't either.
This makes our job
I
easy.
had my chat open. I was like, I'm ready to like answer any questions.
Lawyers love to talk. We've got a couple minutes left. If someone wants to jump in with a last minute question, be my guest. I think, is there anything else you wanted to hit today before I turn it over to you finally and officially to wrap up and tell people how they can get in touch with you?
Oh, one more thing.
Yeah, go ahead.
So another like something to consider if you're hiring talent, the unions, SAG-AFTRA, if you're hiring actors, you make sure you follow those rules as well. So that's the only thing I have to add.
That's smart. Yes. In my space, unions are really not a consideration when it comes to hiring people for the C-suite, but that's a pretty important consideration as well. Well, I want to thank the audience for attending today. I thought this was pretty cool. We don't generally do something like this. This is a little bit new to me, but thankfully we have Merlyne Jean-Louis, who is an expert, a wonderful entertainment lawyer.
Thank you.
Tell the folks how they can get in touch with you. What do you have going on in your life?
Yes, and so I am speaking at BitCon, which is sort of like the Comic-Con for influencer marketing space, content creators. It's in Anaheim from June 19th to June 21st. I'll be speaking there. You can contact me. My name is very unique, for better or for worse. So all you have to really do is Google my name and you will find me. You'll find me on LinkedIn. You'll find me on Instagram. You will find my profile on the Pearson Ferdinand website. I joined the Business Partnership in January, a couple of months ago, and I'm very excited to be here with all my esteemed colleagues like Eric, who's brilliant. Make sure you're following his employer lawyer blog because I get it every day. And I'm like, I try to glimpse at it every day to see what I've learned, what I can learn. So, thank you so much for having me. I do appreciate it.
Yes, yeah, and thank you so much for being
Is
here.
my name going to be shown on the thing? I just want to make sure my name going to be shown on.
Oh yeah, it'll be shown. It'll
literally
be
Google my name and you will find me. Seriously, that's all you have to do.
And connect with us on LinkedIn, folks.
Absolutely,
if you're not
please
connected
do.
with either of us, please do. And I'm active there, but Merlyne is probably more active, and she's better about posting pictures and videos, and is more engaging.
No, I disagree. I think you're quite engaged. I love reading your post. It's very informative.
Thank you. Thank you. Hat tip to ChatGPT. It has helped me
listen,
recently with some
I
of my
use ChatGPT
images.
as well. Seriously, because it's made life a lot easier. I think as lawyers, we have a lot to do in general. So I'm happy to use that for my content creation.
All right, folks, we're about to hit the top of the hour. Again, thank you so much. Let's keep the conversation going on LinkedIn, and you'll find all our contact information there. Other than that, again, thank you to Merlyne, thank you to the audience, and everyone have a great weekend. Bye now.
Thanks, Eric. Bye, everyone.